Chairman Hill, Ranking Member Waters, and honorable members of the committee, thank you for the opportunity to testify today. My name is Clara Kim, and I am a Senior Vice President at the Bank Policy Institute. Collectively, our banks employ nearly 2 million Americans, make half of the nation's small business loans, and are an engine for economic growth. Financial institutions occupy a unique position in our economy. To keep the financial system safe and to serve customers effectively, banks must collect, use, and retain data in ways that are different from many other sectors. They have obligations under law to prevent fraud and illicit activity, and they rely on consumer financial data to do that work. This data is necessary for other activities and services, such as underwriting a mortgage for a first-time homebuyer or extending credit in underserved communities. In the decades since the Gramm-Leach-Bliley Act established federal privacy standards for financial institutions, many banking services have evolved from a brick-and-mortar, face-to-face experience to an always-on digital experience. But while the technology of banking has transformed, GLBA has consistently afforded consumers strong baseline privacy and information security protections. Banks operate under a comprehensive regulatory framework for privacy and data use. These requirements are implemented and enforced through continuous supervision by federal prudential regulators. That combination, GLBA plus prudential oversight, has produced a robust, sector-specific federal privacy regime that has worked for more than 25 years to protect consumers while allowing banks to perform their essential functions. The core principles of GLBA have worked well since it was established. In considering changes to the GLBA framework, it will be important to consider the potential for unintended consequences. GLBA was designed for financial institutions with careful calibration between privacy protections and the legitimate, legally required uses of data that keep the system safe and inclusive. It has also proven adaptable. The federal regulators have updated implementing rules over time as technology, cyber threats, and consumer expectations have evolved. A key principle for any legislation in this area must be a national, uniform financial privacy and information security standard with strong, clear federal preemption. Today, comprehensive state privacy laws are typically drafted for a broad universe of entities, some of which are in the business of monetizing data. Almost no other sector has the same responsibilities as banks in terms of using data to manage fraud and credit risk, or that is subject to the same degree of prudential supervision. Recognizing the distinct role of financial institutions, legislatures in most states have chosen to exempt GLBA-regulated entities. Where state laws do reach into financial services, they can unintentionally interfere with core banking activities that can harm consumers or create conflicting obligations layered on top of the existing federal regime. Any modernized GLBA should provide a single preemptive national standard for the privacy and processing of personal information by financial institutions. To the extent Congress looks to incorporate concepts from state privacy laws, we urge a principles-based approach that respects the specific risk profile and legal obligations of financial institutions. Any new limits on collection, use, or retention should allow banks to gather and use information as necessary to provide requested products and services and for clearly disclosed purposes. If Congress is considering expanded individual rights, it is vital those rights be carefully tailored to the realities of banking. Deletion and similar rights must be reconciled with existing obligations, as well as with the need to preserve evidence of suspicious or criminal activity. Data minimization and similar concepts must be implemented in a way that does not inadvertently curtail essential internal uses, such as fraud detection, cybersecurity, risk management, and the development of alternative underwriting models that can expand access to credit for underserved communities. There is also room, in our view, to further streamline GLBA's notice requirements without changing the underlying balance of rights and obligations. Consumers expect a single, clear privacy notice that is easy to find and understand. GLBA could be updated to better accommodate the use of a unified, plain language notice, often made available online, that explains how data is collected, used, and safeguarded. Finally, one of GLBA's strengths is its technology-agnostic and principles-based approach, which allows banks and regulators to adapt to rapid changes without constantly rewriting the statute. If additional guardrails for emerging technology become necessary, they can and should be addressed through tailored guidance, rather than by embedding technology-specific mandates into GLBA. There's also the risk that any prescriptive requirements could quickly become outdated as well. Thank you for your attention, and I look forward to your questions.